Hello, good evening, everybody. If there is somebody who thinks that we would not be punctual, he or she will be in error, because we exactly start 7 minutes after 6 o'clock, in between cum tempore and sine tempore. So that's our way to make a compromise between different cultures, academic cultures. Ladies and gentlemen, dear friends and supporters of the Käte Hamburger Center for Advanced Study in the Humanities, Law as Culture, I would hereby like to welcome you to the forum evening with Professor Dr. Greta Olson at our center, in lecture entitled Futures of Law and Literature. You will report on your research project by the same name. Subsequently, we are fortunate to welcome Laurent de Sutter, who, as another renowned expert in this field of research, will provide a commentary in a very specific function to become a fellow during this year, from October on, and to join us. I start with presenting Greta Olson. I had the luck to do it some weeks ago. It's always very difficult because we are just reducing personalities to some constructions we distribute around the world. Sometimes I had the fantasy to make a DFG project about the way we construct ourselves and by documents and other means, but it's always wrong, and that is why I ask your pardon in advance. You studied at Vassar College in unpronounceable city, New York, at University College London, and at the University of Freiburg, where she received her PhD for a work on reading eating disorders, writings on bulimia and anorexia as confessions of American culture. I think it is very important to know that this was one of your starting points. That means to deal and with the body and the social construction of the body. Then you had the Venia Legendi in American and English literature and cultural studies, by way not by way, but by way of a text that later on became a book, Criminals as Animals, from Shakespeare, Willie the Shake, to Lombroso. In 2009, she became Professor of English and American Literature and Cultural Studies at Justus Liebig University, Gießen. She's General Editor of the European Journal of English Studies, and with Jean Gaquer, the co-founder of the European Network for Law and Literature. Her research interests include, as you might imagine, law and literature, punitivity and security studies. We didn't have the chance to talk about punitivity studies. Of course, some of us know some stuff written by a certain Michel Foucault, who, as I learned today, is also presenting his clothes in a fashion catalog. Thank you very much for having sent me this email, and this is we have to continue on this topic. But punitivity has not been so much in the German context a primary focus of this kind of studies, but it is, of course, a fascinating topic. Security studies, we would like to know more about this field of your research. Critical cultural narratology, and you made several comments during your stay on narratology, and we know we have to take care when we talk about narration, because she will explain us that we are completely wrong in general when we think to know what narration would be. Issues of post-humanism, feminist, and gender studies, what has been, in a way, your starting point. Since April of this year, Greta is a fellow at our center, and we are very happy, glad, honored, and so forth, and enriched by your presence. Thank you very much for being with us in this kind and wonderful way, I have to say this. 2 words to Laurent de Sutter. Next time when he will make his speech, I will invest much more and investigate much more, just to present and to give you an image about this young researcher. But he's a senior researcher from the Flemish Fund for Scientific Research. I won't try to pronounce this very long title in Flemish or Netherlands. He has taught at Faculté Universitaire Saint-Louis and the Benjamin Cardozo School of Law. He's the author of numerous books, incredible numerous books, including recently Théorie du trou, 5 méditations métaphysiques sur une sale histoire de Jean Eustache. Ça vraiment c'est quelque chose. Et en plus, and furthermore, métaphysique de la putain. And something that is also interesting for us, I wouldn't say more interesting, but also a translation of the famous text by Oliver Wendell Holmes, a famous allocation, The Path of the Law, into French, La Voie du Droit. A very fundamental text. He's one of the general editors of Law and Literature, the journal I have here with me, a member of the editorial board of Décalage, the international journal for Althusser studies, and a member of the scientific board of the Collège International de Philosophie, as well as the managing editor of the Les Perspectives Critiques, a series at Presse Universitaire de France, and of the Critical Edge series at Polity Press. So now I have a problem. I would like to explain a little bit what my relation is with this topic. I prepared a text much too long. You will say, he's really boring us. We want to listen to Greta Olson and to Laurent de Sutter. He's really abusing the time just because he's standing here and he's using his institutional power just to impose his views on that. So in order to avoid, I will be very short and will try to come to the main points. Can we learn something by way of looking at literature, whatever we understand by literature? Because even the concept, the notion of literature is so much debated. In order to get a better understanding of the law. And what does it mean? The law in the sense to be understandable at all, whether some principles might be explained much clearer in literature, in poetry, than by way of the abstract text that is only made for jurists and not for the people. So the law in the books and the law in the street, so to say, where there is a lot of tension between the two. On the other side, what might we learn about literature when we are interested in literature? As Germanists in critical studies of literature, by way of making the legal turn that we can observe with Germanists and in a lot of disciplines that work about literature. They say more and more, if we don't have a look at what testimony is, was Zeugen sind, how law is referred to, we don't have an access to the very meaning of literature as such. So one could say there might be a kind of mutual explanation. But in how far is it also necessary in order to understand some deeper lying problems of the law. For example, what the binding forces of the law and where the binding forces of the law come from. Is there any relation of the poetry of legal language, for example, as we can find it in the Declaration of the Human Rights, to the binding forces, the illocutionary effects that John Searle and Austin tries to explain by the logic of the Speech Act, but perhaps it has to do with the implicit aesthetic qualities of the wording. A lot of questions of this kind. And perhaps in order to understand where it comes from that so many, at least in Germany, German writers, famous writers, from Goethe to Handke, came from the law. Where does it come from? Why? What is the subjacent relationship between legal experience and telling stories? Is it the narrative link, the narratology that we need in order to understand this subjacent interrelationship? Perhaps. But this is not the whole story. We are just moving in the Occidental world, and we are moving in high culture. But perhaps it's also important to look at other kind of literatures, at other kind of legal cultures that are behind the literature, and what in the end, that's what interests me at the moment, at least at the most, is are there relations between legal cultures and cultures of literature? This would be great to understand more about this. So in a sense that narrative elements we know from Jewish law, we know from Islamic law, could have to do something with the fact that narrating the law has another structure as in the continental legal cultures, for example. So those are only some of the questions. I could add a long, very long list, but I would be even much more boring to you, and I leave the floor to this very welcome specialist, and I hope that we will all profit, Greta, from your lecture by way of listening and discussing afterwards with you and with Laurent, who will give a comment later on, a shorter comment than your lecture, your main lecture will be. So thank you very much for coming, and we are eager to understand.
Thank you very much. And I'm going to be walking around a lot, so get ready, darling. Part of my thanks to Werner is built into my talk. So Werner, you'll have to wait for a moment.
Okay.
But anticipation can be a good thing. Before that, I need to thank some other people. That would be Dr. Finger, who negotiated, for, as I understand, for a long time, and not easy negotiations with my home university, so that I might have the pleasure of being here. To Raja Sakrana and Nina Detloff, who also have invited me here and part of the selection process, thank you too. And my thanks in particular to your, and I can't name you all by name, but you all individuals, Max Tönnissen particularly today, have been and are incredibly helpful in making our lives here at the center really very wonderful. So, with no further ado, I'd like to give you an overview of what I'm going to do today. And this is the kind of architecture, because I speak freely of where I'm going, so that you know where the argument will hopefully end before I begin. I want to first talk about interdisciplinary play and more complicated narratives. And that has to do with my being here and with the person of Werner Gebhardt. I then want to talk about what I'm going to call old school law and literature and versus current and emerging law and literature. So taking the liberty of being a native speaker, I'm using the plural there. And here I need to reference some of my earlier work so that you know where I'm going with this so that it makes some sense. I'd then like to talk about two narratives about what's going on with law and literature now. One is that it is a demise, that this interdisciplinary venture is exhausted and in fact has outrun its usefulness or utilitarian quality or proliferation. The emergence of law and literature into a number of other law ands and a proliferation. And this includes what should we call what we're doing. I'd then like to talk about some of the directions that law and literature is moving now. This is decanonization, moving away from the original canon of texts that were always used in order to explicate the law, expansion, and towards multimodality in what I'll call the visual turn in law and literature. Fourthly, I'd like to talk about metaphor versus narrative as ways of thinking about law. And I use metaphor here as a kind of bridge because metaphor is, if you will, activating different parts of our brain architecture and has a quality of instantaneity where we see images that is different from narrative, which is causal and more linguistically oriented. I'd then like to talk about the move from law and literature to law and affect, with the question being, if law and literature has now become law and affect, if there's really room still for the literature and traditional law and literature. I'd like to advocate historicizing situated and comparative work. And finally, I'd like to finish, and I want to thank Jeff Redding, my fellow, for saying this in preparing me for what he would say next week. Why should we care? Why should we care? For those of you who are involved in interdisciplinary ventures with law, law and philosophy, law and anthropology, Rechtssoziologie, legal social studies. Why should you care about law and literature? And I hope, Jeff, and the rest of you to have made something of a case for that by the time I'm finished. Okay. I need my notes for this, and this has to do with my thanks to Werner Gebhardt, and I was trying to think about how I could thank Werner, who, as we know, is very generous and has created a salon-like atmosphere, as my friend and colleague said when she visited me here, and who has invited us to play with our disciplines and to play with what we're working on. And I'd like to do that by looking at one of his images. Now, in Sauergarten, Max Weber in Indian could be narrowly read as a form of Orientalism, that lovely and sensuous Orient. But let's look at it more closely. And what I see in the play is a bit of self-irony about the Orientalist aspects. Of course, there's an intertextual reference to Weber's text about religion in India. And there is a quality of intertextuality and interdisciplinarity. We see Weber, as we do in many of Werner's images, traveling through worlds, also in his doppelganger role as a cheetah, a gepard, of course, from Werner Gebhardt there. And we see him, and I see in Werner's very varied work, bits of early Kandinsky, of Matisse, of the Faust, of Warhol, of course, and of Gauguin, and in the central technique, which I would call collage, a mixture of text, of visuality, and the linguistic. And I believe that what Werner does in his images, and I can't speak for you, Werner, is what he is inviting us to do while we have the pleasure of being here. and that is to play. And play, Diavana, is not a usual part of German academic habitus, for those of you who have been institutionalized in Germany as I have been. And valuing play, valuing what that can mean, is a gift for me, and it has also, and this is the downside of play, complicated the story I wanted to tell you. I came into this center with a very teleological project, 1 chapter a month. I'm going to have most of it done by the time I leave. And then I began, and you heard my first book was about eating disorders, a bulimic binge of reading all of you and of thinking about what are other forms of interdisciplinary investigations of law doing. And I've learned, for instance, about legal anthropology's whole discussion of pluralism and the rechtssoziologische discussion, which went either parallel or before it. I've been learning about legal, socio-legal concepts that I was not aware of, like legal consciousness versus living law, or rechtskultur, or legal culture. I've been reading various theories about how law constitutes the social. So my narrative, and the narrative of the book I'm writing, has gotten a little bit more confused, which is to say that I'm learning. And I'm very grateful to you for giving me the room to play and for giving me the opportunity to learn. Okay. In my former work, I was writing something of a critique of what I saw as predominant modes in law and literature scholarship and derivative forms of law and literature scholarship, which was based on the post-1970s emergence of law and literature. One could say, because there are many pre-1970s forms of law and literature in Europe and elsewhere, but as a post-1970 US-American movement, that it was a product of a particular historical moment in a predominantly common law legal system. The American system is, of course, mixed, as are most systems. It was a reaction to the law and economic movement and the emphasis on rational choice theory as a basis for making social policy. It was seen by legal teachers such as James Boyd White, Robin West, Richard Weisberg, as leading to an ignorance of the socially transformative potential of law, legal language, and interpretation. It was also a reaction to the conservatism of the regularist Supreme Court as compared to the Supreme Courts before then. And it was viewed as requiring a critical counterpoint. So it was initiated by law teachers who were unhappy with what was going on, both in a very Supreme Court obsessed and Constitution obsessed culture, and what was going on in legal teaching. Law and literature in this permutation was intended to restore a certain ethics or reverence, a word that both White and Richard Weisberg used to legal practice and legal education. It focused on the drama of the adversarial trial as presented in literature, and most often it was a form of law in literature, how narrative literature is discussing legal themes. It juxtaposed the inequities caused by positivist legal interpretation with examples of contingent justice and alternative forms of education that are presented in and through the narratives of the realist prose novel. There were some texts that were taken up again and again. They are William Shakespeare, Sophocles' Antigone, and Dickens again and again, and Melville's Billy Budd as being in kind of the pantheon of texts that are worked on again and again. Note both because drama has a very strong narrative emphasis, both the emphasis on narrativity and on realism, of seeing the literary as a mirror of socio-legal issues and problems, and it's often in an antinomy with injustice or legalist interpretations of law, as setting up a locus of justice, of equity, going back to the common law court system of equity as a different form of court, and of the merciful. This leads to the fact that a very idealizing, arguably almost romantic image of literature is espoused in much of this original scholarship and that which derives from it. Furthermore, literature is often gendered as being feminine, as being the locus of the good, and as taming, if you will, big, burly, masculinist law. Okay. Now, there are two narratives right now about what's going on with law and literature. One, in a very often quoted article, Julie Stone-Peters from 2005, says that law and literature as we knew it is over. It is no longer efficacious, and it's no longer a good way of thinking about law or critiquing the law. The other direction says law and literature is going in a lot of new directions. But what should we call it? And there is a lot in the name. And each of these names that I'm going to be mentioning also has, of course, its own history and its own interdisciplinary dialogue about what its purpose and what its objects are. So one suggestion is that law and literature, having moved away from a traditional notion of literature, should merge with law and the humanities. And there are several important books that include law and literature, law and film, law and language, law and semiotics, etc. Now the issue here, and it is an issue, is that there are two issues actually, is that one, the idea of the humanities is based on an Enlightenment rational subject as the locus of meaning, as the locus of intentionality. And in critical theory, both in posthumanism, in affect theory, and material theory, there's been an emphasis on decentering this Enlightenment thinker, rational locus of all things, and moving away from the Enlightenment subject, which is the basics of humanities pursuit. The other issue, and this is an economic issue as well, is that the humanities, as we know, is in a difficult state of defending itself everywhere. So that as a project in general, we find ourselves, wherever we are in the world, defending ourselves about why should we be doing what we're doing. Another suggestion is that law and literature should merge, or should see itself as part of the larger law and culture movement or discipline, most often associated with legal anthropology. A difficulty here is that culture, as we all know, is an enormously contested term and concept. And here I would think of Raymond Williams and his concepts, and that the idea of culture as a contested subject becomes unclear. What are we talking about? Are we talking about practices, significations, or some assemblage of both? Very often, the suggestion is that law and literature should move into law and aesthetics, which has usually been about law and poetry, or law and the arts, and law and visual culture. In other words, with upholding the part of law and literature which is about the fictional and about the explicitly aesthetic versus the legal. Again, law and literature as law and narrative, rhetoric, language, semiotics, all much more language and rhetorically focused, or law and popular culture. These are all directions in which law and literature is going. My point here, as we think about this, is to see are pursuits possibly, and this is not to treat them simplistically, but as being gap studies, as addressing what has often and repeatedly been talked about as the gap between the letter of the law, the written law, the intention of law, and law as it is actually played out on the ground. And that all of these movements and their various objects and methodologies have to be seen in relation to law and literature. So the plea I would be making here for interdisciplinarity is that we have to look, even if it means becoming very confused, as I have done, over the borders of our own discipline into each other's backyards, if you will. So, from that first, or those first critical essays, what I've seen going on in law and literature research has been, first of all, a decanonization. And this is partially an acknowledgement of a decanonization that has gone on in literary departments in general, which is to think about literature also being involved in ideological projects about gender, about race, about ethnicity, and particularly about class. And to think about the traditional canon and what kind of politics were behind that, supporting that. So what I've seen is there has been a move away from Anglophone and the Western canons of literature, away from that short list of Shakespeare, Dickens, Melville, and perhaps a few Greek tragedies. There is, and part of this, and here I'd like to briefly mention Laurent de Sutter's article on Tristram Shandy. Now, Tristram Shandy, a wonderful, playful 18th century novel that's plays with visuality and was postmodern before its time, is part of the literary canon in English literary departments. But it has, to my knowledge, before you worked on it, never been seen from a legal perspective of how it interfaces with law. There's now an interest in what we used to call problematically, and with a lot of value judgments involved, marginal literatures. And there are now law and literature articles on science fiction and children's literature, which used to not be considered as having enough gravitas in order to be in dialogue with law. I see in the languages that I'm able to work in and the translations that I see a lot more analysis of non-Anglophone literatures going on. And here there is a problem of getting this work known when the lingua franca is indeed English at the moment. And an analysis of non or less narrative genres such as lyric poetry. Of poetry, prose, and poetry, prose, what's the third one? No. Thank you. No, that's prose. Poetry, prose, drama. Thank you very much. Those are my fellow literary studies women over there, helping me with my blackout. Lyric poetry is always seen as being non-narrative, not as being, and we think very much of it in romantic terms, as evoking emotion, as evoking a moment, as in the original meaning of lyric of a song, and not as having narrative content. Again, to think of this in this way is to move beyond that original small list. Another move has been to multimodal texts. Now, why do I say multimodal rather than multimedial? Multimodal comes from linguistics and means not only the media through which a text is sent, but also the senses through which we perceive it. So to think about the exchange involved in how we work with text. Now, why is this? And I want to try to make this as brief as possible. One, there's been a move within literary departments in general to become cultural studies department and media studies department. Part of this has to do with decanonization and the awareness that calling, as it is in my university, a department in English or an American literature department is a nationalist project. It is partially in tune with the work of post-colonial work, which shows how in the colonizing nations, national literatures, and they're being taught in colonized countries, was a form of ideological, if you will, perpetration and also a displacement of the local literary cultures that were there. To call the department now German, English, American, we can only do that self-consciously. Further, an awareness through cultural studies in general that what we used to call and simply explain as high culture, Goethe, Shakespeare, opera, is also an expression of social habitus and an expression of class and a way that we express our cultural belonging in the world. And to trouble that distinction and to say that the high and low is something that we have to think about critically while we still want to consider aesthetic value. Third, it is a move towards media studies, and that will take me to my next point. W.T. Mitchell describes what is called the visual turn, a movement from Western cultures that were primarily defined by the linguistic and the rhetorical to are now taking in most of our information and exchanging most of our information visually or also digitally. The visual turn entails also changing technological and media conditions. There's a large argument out there that what is problematically called quality television, a new form of storytelling and television that's taken place roughly since the 1990s, which is more like auteur cinema with much more complicated storylines, much more interwoven narratives, much larger budgets, that in television has perhaps become the place now where we discuss social issues rather than what used to be called the social novel. Further, there's an argument from popular media and popular legal studies that the main sources of information about the law actually come from television shows and from films. 70% of what we watch in the world is made in Hollywood. However, there's a very strong argument that in terms of how it gets interpreted or taken into local cultures also involves forms of adaptation and localization. So, literature in the traditional sense, most often in the form of the realist novel. And the realist novel is wonderful, it's what most of us like to read, but it's also problematic, one could say, because it does not in any way disclose the issue of mediation. As James Coetzee writes, it's a way of owning the world through words, a problematic way of owning the world. It may no longer be the most interesting or viable aesthetic other with which to interrogate law and law literature scholarship. Rather, notions of legal culture and aspects of legal consciousness are more often debated on and disseminated through television series and other popular images and media of law. In other words, literature does not have to be seen as coextensive with the realist novel. The literary, understood here in a wider sense, also comprises visual and multiple modes as aesthetic vehicles for expression. This, albeit controversial, understanding of the literary includes then a focus on fictional television series and film relating to law. Now, again, I'm going to use a shorthand to talk about that. Within law and within aesthetic studies, and particularly in that interface between law and the other, there's a strong case for a historical distrust of images. Cornelia Wisman dates this to the 1st century, to Quintilian, and to images of the young woman unclothing herself in court, and the way this was increasingly seen in law as debasing the law. this belongs to what is called, and there are two understandings of the CSI effect. This is in relationship to an incredibly popular series of American television shows called Criminal Scene Investigation. The CSI effect says, in the narrow sense, that people who watch CSI, and it's an extraordinarily popular series of shows, believe that, as in these shows, which are about forensic investigators, you will have incontrovertible physical evidence about who committed the murder. And usually the normatively beautiful actress with the big breasts goes, and 1 second later, boom, there's the perpetrator. So in the narrow sense, it's that belief in science, if you will, and in forensics that there should be certain proof of who did it. The larger effect, CSI effect, is that, as suggested by Richard Sherwin, also by Lawrence Friedman, in essays called Lexitainment, is that the form of popularizing law through television and film has actually led to changes in legal practice, to the use of the need for more media and visual evidence within the courtroom, and also a distortion of legal culture that it should go on with the same drama that we see within court shows or within forensic shows. I want to play with that fear of images for just a moment and say that it ultimately goes back to Plato and the notion that the image of the table is 3 times removed from the reality of the table. And that fear of media or images is something that's very, very strong within Western history, and just to trouble it continuously. As a way of working with this expanded notion of literature, I would advocate using intermedial narratology, using the science of how narratives work, but keeping in mind media specificity, that we can apply linguistic structures and their forms to texts that also work differently, and to visual cultural studies. So not cannibalizing other forms with narratology, but also thinking about their specificity. Okay, as a moment, thinking about metaphor versus narrative as 2 leading modes of how people are doing law and literature now. Why metaphor? As I would attest in accounts of metaphor, of cognitive metaphor theory, or of metaphor as a form of mental mapping. The metaphor putting in place my love a rose, the more familiar thing, the rose, in order to see or understand the less familiar thing, is a very different kind, arguably a more visual activity than narrative. Within the last 20 to 30 years, there's been what's also been called a narrative turn, of suggesting that narrative structures are primary to all kinds of experience and comprise a central form of world making. This suggestion, which is in some ways problematic, Peter Brooks, a leading figure in this field, has on his university website that it's a universal grammar narrative in the same way that Chomsky describes language as a universal grammar. Problematic because, as are so many things that are prior to experience, it's difficult to prove. One of the ways of seeing narrative and its overlaps with the literature are the very clear parallels between literary and legal genres and narratives. And again, I'm using shorthand. Very often we refer to the work of the late Robert Cooper and his suggestion that for every legal text there is an epic or decalogue that goes with it. Robin West, in one of her earlier books, describes how law goes along the different genres of literature: tragedy, comedy, history. Austin Serret, another American researcher, has suggested that the whole debate and trials about capital punishment take part in the form of a melodrama, so that these basic genres inform the legal process. In work that I find very exciting, Joseph Slaughter has been working on the overlaps between the Bildungsroman, the novel of education, and human rights discourse. Another direction that law literature has gone in is it's no longer law so much as human rights discourse and literature. He argues that 18th and 19th century Bildungsromane lent narrative, structure, and plot form to international claims for human rights. These claims to human rights are based on the discursive conventions and are not revolutionary, but rather reformist in nature, and may work to reproduce the social status quo. So as in a lot of critical work about human rights discourse in general, Slaughter shows both the nationalist investments that often go along with claims for human rights, because it is ultimately states that have the sovereignty to guarantee that human rights are supported, and the forms of exclusions that go on when human rights are claimed. So one way that law and literature go together is in the generic overlap, the borrowing from the literary in order to inform the legal claim. Here in the Bildungsroman, as Slaughter sees it, one claims, one begins the narration by looking back to a time when one wasn't included in the community, and ends the narration from that form of inclusion. And that this form of the narrative is also the way that rights are claimed for. A second point is for overlaps in the narrative sense, that cultural and legal narratives both work as forms of self-legitimization and are very important to national discourses. And here I'm quoting Rajas Sakrani in a forthcoming article. As Werner Gebhardt has argued in support of his transdisciplinary comparative study of law, the identitary function of law is linked to the birth of the nation state. This function is often underestimated in the functional catalog of law. And further, as he hypothesizes in the text she refers to, the particularities of a legal culture and its form of normative self-legitimation are closely connected to its preferred genres and narratives. I hypothesize that during moments in which the articulation of a national identity is perceived as an urgent matter, questions regarding the interrelation of law and literature or law and the aesthetic become urgent, because both national literatures and the nation's legal systems are viewed as particularly authentic manifestations of a given linguistic and cultural identity. And then looking back at a pre-1970s origin of law and literature, in the German territories after the Napoleonic Wars, a sense of nationalism preceded the later consolidation of the country. So, summarizing the work of Theodor Tsiolkovsky in The Mirror of Justice, which deals a lot with Germany, literary portrayals of justice are stimulated by crisis points in legal history. So actually this is mixed around, we should go to Germany. German historical scholarship has focused on the simultaneous development of Romanistic and Galmanistic as both philological approaches to literature and language, and as distinct and contrary basis for the formulation of a unified German law during the Sattelzeit. And the famous, very often quoted and unfortunately not translated text by Jakob Grimm, Poesie im Recht, describes long before the 1970s why one has to go back to German customs as a way of doing law, and to avoid what we might now associate with law and economics, of seeing law in a quantitative fashion. To go back, all of African American literature up until the 1960s, in which with the Civil Rights Act in particular and the Voting Rights Act, real changes were made in the legal conditions of African Americans essentially concerns the law. And this is because of the lack of legal redress that African Americans had within the United States. Literature became a place of addressing that lack. In Brazil, Lila Lehman describes the work of authors such as Rufato, who spoke at the Frankfurt Book Fair last year, Fernando Bonassi, Perez, and Marcos Faustini, and their performances of citizenship in the literary realm. She attests that the insufficient socioeconomic, civil, and cultural rights in Brazil have been met with a reclaiming of citizenship via cultural expression. In other words, when access to civil liberties are lacking, literary and aesthetic can be a place where they are claimed and played out. So, now moving gears, and I don't want to overtax you with too much information in theory, I believe that law and literature has been replaced by what I would call law and affect. In what has been called, and we have to be careful of how many terms we want to throw around, the affective turn. Since the 1990s, there's been a rediscovery of Baroque Spinoza's work, via, in particularly, Deleuze and Guattari, a working through the neurobiologist Damasio's work, and the philosopher Brian Masumi's work, and Rosie Bradotti's. And again, this belongs to my troubling of law and humanities. There is in this work a desire to decenter the post-Enlightenment subject as the center of intentionality. And rather of thinking of rationality and intentionality as the basis of all experience, there is an emphasis on the primacy of relation, of nodes, how things relate to each other, and to material experience. This is also very much akin to issues of post-humanism. So what I now see going on in law and literature is titles like, and these are all recent titles, Madness in the Law, The Expressionless Law, Ethics, and the Imagery of Suffering, and Law and the Passions, a book that will come out later this year. Describing why we need to look at passions, from a recent article, Julia Shaw and Hilary Shaw, affect and emotions have the capacity to act as a means of strategically theorizing aspects of legal culture which are otherwise overlooked or repressed, and as an indicator of insufficiencies with mainstream legal discourse. So the antinomy that is setting up now is not law and literature, law, legalist, meaning positivist, and literature, locus of the good, the contingent, the feminine, etc., but rather how do we describe what can't be described with law in emotion and in affect. And affect is differentiated from emotion as being prior to emotion, which is already gone through some kind of rationalization process. A second part of the move to affect, and this is again in claims for human rights, is that by appeals to shame and to embarrassment and to witnessing the suffering of others through personal testimony, very often claims to rights are made. So personal narration of and testimony to experiences unattended to by legislation have become vehicles for raising public notice of how rape and sexual slavery are regularly employed as systematic forms of oppression during wartime. The rights of indigenous peoples have been rendered tangible through personal narrative, and these narratives have contributed to challenging the legal status quo. Commenting on how narrative and function as a force of legal emancipation, Schaeffer and Smith write, emergent in communities of identification, marginalized within the nation, such movements embolden individual members to understand personal experience as a ground of action and social change. Thus, what I'm suggesting is that affect has become, in the Derridean sense, a supplement, the supplement to law, perhaps instead of literature. And the question is, can literature still have a place in that?
So, and I'm getting towards the end, if you're feeling overwhelmed. I advocate a move in law and literature scholarship towards anti-monolithic discourse. And I suggest that we need to historicize our work that does not treat either law or literature as absolutes, as non-processual. The monolithic rendering of law as ethically challenged and manly, and literature as a repository of teaching the good and feminine, has failed to address the latter's enmeshment in hierarchies of power. One needs to be just as candid about the ideological commitments of literature and literary evaluations as one is critical of abuses of law. In the history of literature, particularly the field I know best, English literature, we've now talked very distinctly about how gender, sexual, and particularly class hierarchies were also supported through literature. Literature can be critical, it can also redefine the dominant values of a society. So, citing Frederick Jameson's much-quoted appeal, I would suggest that we self-reflexively always historicize our law and literature scholarship. Now that's a lot of theory as an opening, and not too clean teleology of the various directions that law and literature are going, and there are more. Let me try to make this more concrete by giving you some actual suggestions. And here I've mentioned a lot of other friends and scholars' works. I'm going to talk about 3 case studies that I've done. In 16th century England, not yet Great Britain, there was what was called a chapbook or a pamphlet. They're now called road pamphlets, descriptions of various kinds of roads, common thieves, from originally 1566 from a public servant named Thomas Harman, a caveat for common personers, what we call vagabonds. Thomas Harman poses himself in this short book, if you will, as being a kind of sociologist who interviews the various roads that walk by, who want money, who he sees and he talks to. And the central issue, and he describes rogue criminal vocabulary and the various kinds of rogues there are, is the issue of pretending. Nicholas Jennings, and this is an illustration from a later Harman copy, they were plagiarized constantly, is Nicholas Jennings pretending to be sick and not able-bodied and unable to work, and clever Thomas Harman forces him to bathe, etc., to see that he is really very able-bodied. This belonged to in England, after the demise of a Catholic sense of needing to succor the poor, to an increasing notion that the able-bodied poor created their own problems and needed to be punished, and a real punitivity, and a kind of discourse about the poor that I would argue stays up to the day. Now, I make an argument like Slaughter does, that this literary form influenced later law. And this is the Poor Law of 1572. It is now published, declared and set forth by the authority of this present Parliament that all idle persons going about in any country of the said realm using subtle, crafty, unlawful games or plays, and some of them fawning themselves to have knowledge in physiognomy, palmistry, and other abused sciences, whereby they bear the people in hand, they can tell their destinies, deaths, and fortunes, and such other like fantastical imaginations. And I left this in because it's about a class of folks. And all scholars of the University of Oxford or Cambridge that go about begging, not being authorized under the seal of the said universities by the commissary chancellor or vice chancellor of the same, and all shipmen pretending losses by sea, other than such as shall be hereafter provided for, and all persons delivered out of jails that beg for their fees or to travel to their countries of friends, not having license from 2 justices of the peace of the same country, etc., shall be taken, adjudged, and deemed rogues, vagabonds, and sturdy beggars. In other words, punishable with increasingly punitive means, including branding, putting in stocks, and being carted off. The list that are in these literary pamphlets literally became the list that was in the Boer laws, as did the whole discourse of pretending. So this is a case where the literary form or genre directly affected the legal statute. In America, our president is often referred to as the drone president. And we have an issue continuing in the United States about what is the legality or illegality of the use of drones as a counter-terrorist measure. And these guidelines have not been publicized, and that is difficult. In the series called Homeland, a very resonant name since we had a new Homeland, Department of Homeland Security in the post-2001 attack era, in an episode called Crossfire, a prisoner of war in Afghanistan, Brody, who has been taking care of and tutoring a young boy, the son of a terrorist leader named Isa, witnesses his death along with 82 children when his madrasa is hit in a drone attack that was knowingly authorized by the vice president and subsequently covered up by the CIA. Arguably, the fictional form and the critique of drone use, which is of course through the white man experiencing the loss of a child that is a substitute for his child, but allowing us into that sense of emotion of what this loss would be, has provided a forum for discussing extremely problematic US-American policy, which we are not having publicly, or only inadequate. Moving to our own Germany, Daniel Levinsky. Who here knows Daniel Levinsky other than me? Okay, you introduced it to me. Daniel Levinsky is ein Euro-Anwältin. She is someone who studied law, having come from a actually lower than working class background in Neukölln, in a very poor part of Cologne. And because she cannot get a regular job at a law practice after graduating, she sets up a table in a shopping center and charges for her legal fees €1 an hour. Now, in this episode, Scheidung of Islamisch, roughly divorce a la Islam, demonstrates current anxieties about Germany's increasingly heterogeneous populace and how this heterogeneity may affect German law. Here we have young lovers, a married couple, he Muslim, she German, married under both German and Sharia law. And he has verbally divorced himself in a state of jealousy from his wife. And Danny tries to find, in a very, if you will, pluralistic way, such as suggesting that the wife was menstruating when he said divorce for the third time, hence the divorce isn't actually followed through, by suggesting that the woman marry another Muslim briefly for a day so that she can remarry her husband. We have a working out of, I would argue, anxieties about what's going on in German legal culture now. And here in a comedic format, we're dealing with what is often the specter in German discussions of plurality, which is Islam and Sharia law. And to trouble that, think about, on the one hand, we're trying to work that out. On the other hand, we are also potentially othering the Muslims within us and the notion of Sharia law as the opposite of state law. So, Jeff, all of you, why should you care what's going on in that interdiscipline that may not have anything to do with what you're doing, which is called law and literature? Number one, paraphrasing Peter Goodrich, its literariness and metaphoricity. In other words, we need to use the work, the tools of philology in order to uncover the way that law legitimates itself by insisting that it is not aesthetic, it is not metaphorical, it is not unconscious, but entirely rational. Literary and aesthetic form is political in itself. And here I would cite Raymond Williams, Rancière, Chantal Mouffe, a number of other thinkings that say that the aesthetic form is in itself creating social change. It is not simply a reflection of the reality, it is also can implement change. It can uphold dominant ideological structures, and it can critique them. Thirdly, socio-legal issues are debated in aesthetic and fictional forms. In the two texts I just cited, Homeland and the drone policy on counter-terrorist measures in general, and Shaikhov Islamish as a way of describing tensions that are perceived between Sharia law and German private law. Thirdly, keeping in mind that the articulation of national literatures and legal systems is also a patriotic venture that involves exclusions, as in human rights discourse, that these overlaps happen very particularly during moments where there are problems in legal culture. I'd like to cite a text that Herr Beckenförder told me about, are from the Käte Hamburger Kolleg on globalization. And it is called Law Made in Germany. And listen to the patriotism that sues and sees through these words. Made in Germany is not just a quality seal reserved for German cars or machinery, it is equally applicable to German law. Our laws protect private property and civil liberties that guarantee social harmony and economic success. I would argue that given the fact that the literary and the legal also involves attestations of the national and of the patriotic, that we need to take critical methods, critical literary and cultural studies methods, in order to be canny about what it does. Thank you.
Thank you very much for this brilliant talk. I'm very happy that we have prepared a podcast, because it will be transliterated and we'll publish it, distribute it. We go into the cities, in the courts, and just to make it understandable, readable for everybody. Okay? Thank you really very, very much, because as well the critical aspect as well as the wide range of the disciplines involved in cultural studies, as we formerly said, but perhaps where after all the turns you were mentioning, we have to find and look for new words. And so you did in the end, saying, or during the whole discussion, that from literature we have to move to visuality and so forth, and affect and the senses. And I would say also the sense of justice, for example, that has an emotional side, and law and the emotions is something much too much excluded. Though at the beginning of the discourse in the 19th century, emotions and affect was very, very close. The theory of punitive justice in Durkheim is just about the re-establishment of an emotional order that is disturbed by way of the criminal act as such. But as you rightly said, it's not just about controlling emotions, but it's also to listen to emotions, to understand what emotions say. What emotions say when we are looking, we are witnessing sufferings and so forth. And what does it mean for our understanding of human rights, for example, etc., etc. A lot of problems. I have to stop here in order to give the floor to you, but not without saying how much, dear Greta, I was really, so I had a lag myself because I wanted to say Gabo and it was just Greta, excuse me, how much I really was moved by your interpretation of Weber in the Enchanted Garden of India. You understood everything and even more than I understood, and so I have to be more careful to display those pictures. Thank you very much. And now it's your turn, and I'm really curious to know how you react to this brilliant talk. But there is another brilliant person, I fear. Go ahead.
Thank you, Werner. I think, except for, kissing Greta, I think I have difficulty to think of other things to add to when she said, this marvelous mapping of the current state of affairs as far as law and literature is concerned. But before kissing her, I will thank Werner, of course, for his very kind invitation to join you today and to react to this talk, to express to express my own emotions about it. And so thank you very much, Werner. I'm very honored to be here, to be amongst you in this very beautiful place. And well, I hope that we meet again very soon. The reaction that I will have, I mean, I cannot supplement what has been said. So the only one thing I could do is to echo it into some other, some other vocabulary, some other terms to describe, as a matter of fact, coincide the same program as the program described by Greta. So I would just, very shortly, I would like to review 7, let's say, features of what I think the future of law and literature is about. I would like to review them. They cross what Greta has said, but again, they cross it with other words and other terms and maybe other theoretical preoccupations than the preoccupations that Greta has, but basically it's the same. I think that the main lesson, or the first lesson that we have heard from her talk, is indeed the question of the relationship that fiction has with reality on the one hand and with the real on the other. And I would say that the problem with law and literature, or the interest of law and literature, or the thing that's worth looking for literature, for films, for series, and so on and so forth, is of course that fiction matter more than reality in order to understand what law is all about, because law indeed is all about fiction itself. If in order to get to the real of law, we have to avoid the never-ending call to go back to the reality, the factual reality of law as it is implemented in rules, in regulation, in actual administrative disposition, so on and so forth, which matter, of course, and which matter a great deal. But the imposition of the discourse of reality as being the only one access to law is something that most of the time renders it's real in terms, in Lacanian terms, it's real as it goes through the reality, as this thing that goes through reality, and that, as a matter of fact, illuminates the underlying hypothesis, or the underlying framework within which it is embedded, is something which is, to me, of the utmost importance. And that's why, let's say, that's the very starting point for future endeavors in law and literature, to agree on that, to agree on the primacy of fiction upon a reality. That would be, let's say, the first claim I would do, which would be an ecological claim. The ecology of law is the ecology of fiction. The second claim that I think we could, and that's what, of course, the fear of images that Greta was talking about, is, of course, something which is not simply the fear of the images as, you see them in the movies or in art museums, the fear of images in general. The second claim I would like to make is not an ecological claim, it's more an epistemological claim. What can we learn from law and literature? Well, we can learn the art of the detour, the art of what Slavoj Žižek called the parallax view, to confront ourselves directly, frontally, to a reality, whatever it is, such as law, is the best way to avoid it. In order to see how it unfolds and how it breathes throughout the world, it's always better to look at it, you know, from a slight angle, like these, you know, this phenomenon, this visual phenomenon that you slightly notice, but that which are much more important to the scene than the actual scene itself. The parallax view that Slavoj Žižek speaks about is to look at the things that are peripheral to your angle of vision, because it's at this very place that the question of the real arises. It's not in the frontal contact with the thing, the frontal contact with the thing that can only, let's say, the only one thing that you will meet frontally is reality itself. That is precisely the thing that you want to avoid. The third thing, I'm making some kind of a manifesto, you know, so it's as arbitrary and as impossible to ground or to found as any kind of manifesto, you know. So the question of agreeing or not with that is not simply a problem, as you will see later on by one of the further claims that I will do a bit later. So the third one I would do is indeed a question of strategy. Why would it be interesting, or why is it interesting to go looking for fiction in order to make this detour? Well, I would say that the strategy here could be a strategy of contamination. And maybe what law and literature can help, compared to the very technicity of law being you know, different disciplines of law, the history of law, comparative law, and so on and so forth. The virus is more contagious. It's easier to spread, something that we can make circulate in a, let's say, more efficient way than simply, you know, repeating, as it was done in the 1970s, repeating and arguing again and again for the inner dignity of law. You know, when you repeat, you can claim that as much as you can or as much as you want, but if the sociologist you have in front of you, if the anthropologist you have in front of you, or if the philosopher you have in front of you is not interested, you will never interest him or her by simply assessing or asserting the inner importance of the thing. You have to somehow convince it. You have to contaminate it by some kind of curiosity towards what law can offer. And here again, this very bizarre trend, or this very bizarre perspective that law and literature is, I'm persuaded, could produce this kind of reaction, or reaction in chain, by arising curiosity, if it produces something like interesting consequences, or consequences that can be appropriated by other disciplines as well. That would be precisely the next claim I would do. Not an econological claim, not an epistemological one, not a strategical one, but let's say a methodological one that goes with it. You can also formulate a program of methodology that is very serious, very sound, for strong research and so on and so forth. Apply for funding for that. And of course, when you would do that, I mean, the traditional way of making science, so to speak, the question of methodology will always be of a primary importance, because methodology is what, let's say, puts the thing into some kind of a frame that defines an order before the things are even investigated. Methodology is the thing that, let's say, will orient the breathing of the thing that you're looking for in a certain direction rather than another. I mean, the choice for methodology is something which is always looking backwards. It's looking for a precedent state of affair, which afterwards is implemented on the reality to which it's supposed to apply. What I think law and literature can help us, because of this bizarre status it has, or this lack of status it has, and this kind of porosity it has, would be what I would call some kind of a pirate epistemology, a pirate methodology. That is, rather than defining in advance the process through which you are going to encounter your object, it's the object itself that will define the type of trajectory or the type of journey you are going to make. And in this journey, the only principle, which is not so much of a principle, that will matter is, of course, that nothing matters. The only principle that matters is the fact that in your inquiry, by way of hypothesis, the only one hypothesis that you can get is whatever works. Okay? Whatever works, as long as it produces sound consequences, and as the construction of the consequences is what arises from your methodology. rather than going backwards to the realm of cause, you're looking forward to the possibility of producing consequences and of producing the chain of consequences in a robust way. So this is some kind of a trial that you impose yourself in your inquiry when you're looking forward through an encounter with a literary or visual work. Of course, this might sound quite extravagant or even frivolous, especially compared to what you said earlier about this claim to seriousness that lawyers may have, and that even law and literature early proponents would have. And indeed, it is. I could not deny that. I mean, it has the sound of extravagance to it. But I believe that what we have heard from Greta is that to follow this path can lead us to conclusions, or can lead us to consequences that could not have been foreseen by the very state of affairs that lead us to enter into this field. The fact that law and literature is changing, for instance, and it's changing in order to illuminating all the new dimensions of both the work that we are looking for and law on the other, is part of the type of surprises that the softness of law and literature as a discipline has produced throughout the time. Has produced throughout the time thanks to this, let's say, embarked principle, which is the primacy of the object. The fact that the object is always more clever than we are. It's simply what matters when you look at a work of art, whatever it is to be led by it rather than to try to lead it somewhere that you knew before. So these are, let's say, the very few remarks that popped into my mind, which are very general remarks. We could discuss it for years, but Vanna asked me to speak only 10 minutes, and I'm sure that I'm already too long. These are wild and savage, in Deleuze's terms, remarks, but I think that they complement, maybe in an extravagant way, what Greta said, and with which, again, I can only repeat, I could not agree more. So thank you.